Yes, North Carolina is one of a small handful of states where a betrayed spouse can sue the person who interfered with the marriage. 2 civil claims do that work: alienation of affection and criminal conversation. Both come with rules that are far stricter than the headlines suggest. Here is what each one actually requires. Alienation of affection is a civil claim against a third party who wrongfully destroyed the love and affection in your marriage. To win, you generally have to prove 3 things: that you had a genuine marriage, one in which real love and affection existed, that the love and affection was alienated and destroyed, and that the defendant's wrongful and malicious conduct caused it. You also have to show damages flowing from the loss. 2 features of this claim surprise people. First, the defendant does not have to be a lover, and you do not have to prove an affair. The classic defendant is an affair partner, but a meddling in-law, a friend, anyone whose intentional interference destroyed the marriage can be liable. What matters is malicious interference, not sex. That said, when a sexual relationship is proven, courts treat it as powerful evidence. Second, malicious does not require hatred. It means intentional conduct the defendant knew was likely to harm the marriage. Pursuing a married person qualifies. Criminal conversation is the second claim, and despite the name, it is civil, not criminal. Nobody goes to jail. The remedy is money damages. It is also far more mechanical. You have to prove exactly 2 things: that a valid marriage existed, and that the defendant had sexual intercourse with your spouse during the marriage before you separated. That's it, which puts it close to a strict liability claim. A single act is enough. I didn't know they were married is not a defense. And your spouse consented enthusiastically is not a defense either, because the claim belongs to you, not to your spouse. Your spouse's willingness is legally irrelevant. Because the elements are so different, the 2 claims are almost always filed together. Criminal conversation covers the proven affair. Alienation of affection covers the broader campaign that destroyed the marriage. These claims can only be brought against a natural person, a human being. You cannot sue a corporation or an employer whose workplace enabled the affair or any other entity. Within that limit, the defendant can be anyone whose conduct fits the elements. An affair partner, and for alienation of affection, potentially a parent-in-law, a sibling, a friend. In practice, the overwhelming majority of these suits target affair partners. Can you sue someone who lives outside North Carolina? Often, yes. Our long-arm statute reaches out-of-state defendants when the injury happened here, subject to constitutional limits. Where the defendant lives matters less than where the marriage was wrecked. 2 rules control the timeline, and they end more of these cases than anything else. The first is the post-separation bar. No conduct that occurs after you and your spouse physically separate with the intent of either spouse that the separation be permanent can give rise to either claim. If the relationship between your spouse and the defendant began only after your separation, there is no claim, no matter how painful the timeline feels. The second is the statute of limitations. You have 3 years from the defendant's last act giving rise to the claim. And because of that post-separation bar, the clock is effectively tied to pre-separation conduct. In most cases, it runs from around the date of separation, not from whenever you happen to discover the affair. Together, those 2 rules create a hard truth. If you separated more than 3 years ago, these claims are almost certainly gone. If you are inside the window, do not sit on it. One nuance from our Supreme Court: evidence of what happened after separation is not automatically useless. It can corroborate pre-separation misconduct, but only if you have real evidence more than suspicion that the wrongful conduct began before you separated. A hunch alone will not do it. These cases are built from ordinary proof, carefully assembled in 3 categories: evidence the marriage was genuinely loving before the interference, testimony from you, from family and friends, photos, trips, anniversary cards, the texture of a real marriage. The defense will argue the marriage was already dead. Your job is to show it wasn't. Evidence of the defendant's conduct: texts, emails, call records, travel and hotel records, credit card statements, social media, private investigator observations, witness testimony, and evidence of causation and damages, how the marriage changed and what you lost emotionally and financially. One caution before you start gathering: North Carolina has real legal limits on recording, GPS tracking, and getting into a spouse's accounts, and crossing those lines can create liability for you. Ask before you collect anything. For alienation of affection, the defenses track the elements. The love was already gone. If the marriage lacked genuine love and affection before the defendant appeared, there was nothing to alienate. That is the workhorse defense in nearly every case. No knowledge of the marriage. A defendant who genuinely did not know your spouse was married cannot have intentionally interfered with it. Consent or connivance. A spouse who agreed to an open marriage or encouraged the relationship cannot later sue over it. Plus the post-separation bar and the statute of limitations we just covered, and as a practical, not legal defense, inability to pay. For criminal conversation, the list is much shorter. Ignorance of the marriage and your spouse's consent are not defenses. The realistic defenses are that the intercourse did not happen, that it happened only after separation, or that the claim is time-barred. Our appellate courts have also rejected constitutional attacks on these torts. They remain alive here even as most states have abolished them. Juries can award compensatory damages for the loss of your marriage's love, companionship, and support, for emotional distress and humiliation, for damage to your health, and for genuine financial losses. They can also award punitive damages where the conduct was willful and malicious. North Carolina verdicts have run from nominal amounts to very large judgments. But before the numbers turn your head, ask the collection question: can this defendant actually pay? A large verdict against someone with no assets is a piece of paper. Any honest evaluation of one of these claims starts with the defendant's balance sheet, not with headline verdicts. Sometimes, and sometimes emphatically not, here's what we walk through with every client considering one. Leverage. A credible claim can change the dynamics of a divorce negotiation. It can also blow up an otherwise workable settlement climate. Exposure. Litigation runs both directions. Your marriage, including its private struggles, becomes evidence, and discovery is invasive for everyone, including you. Cost versus collectability. These are full-blown civil jury cases. If the defendant cannot satisfy a judgment, you can spend a great deal to win nothing. And your own timeline. Dating someone new before you are divorced is legal, but in North Carolina, you are not divorced until the judgment is entered, and conduct during separation can still complicate your alimony case. If you are the one being blamed, note that dating someone who is separated cannot by itself create liability. These cases are emotional by definition. They exist because something precious was taken from you. That is exactly why they deserve a clear-eyed evaluation before you file. The separation date rules are unforgiving, the 3-year clock is hard, and the right move is different for every family. At McCrary Pack, we help clients weigh these claims honestly. When to bring them, when to use them at the negotiating table, and when to leave them alone and protect your peace instead. Family law for Iredell, Catawba, Alexander, Caldwell, and Burke counties, where clients are neighbors, not numbers. If your marriage was interfered with, the full guide is linked below. Reach out and we'll give it to you straight.